Welcome to Court of Protection Briefs. Today, a reaction to the Supreme Court overturning the acid test for deprivation of liberty from the case of Cheshire West. This video takes a different approach to many of the responses I've already seen, which fall on the side of criticising, lamenting the ruling. I'm going to utilise the judgment to illustrate the approach the court took to help understand why. Now, creating a test, the acid test, that covered everyone, everywhere, all of the time, was a lofty principle that was a practical impossibility. First, for the courts, here the judgment quoted Dr. Lucy Series. The volume of applications to authorise deprivation of liberty after Cheshire West overwhelmed the system's administrative and judicial safeguards. Paragraph 99. Baroness Hale was quoted then in the next paragraph. Alarming practical consequences. The court itself said, if Cheshire West is correct, then backlogs in the processing of doles authorisations and applications for court orders mean that hundreds of thousands of people are being deprived of their liberty unlawfully. Paragraph 101. Attempting to apply Cheshire West created a system that was unworkable. It prevented the court from properly dealing with thousands of cases where Article 5 issues need addressing. There was also the issue of clinical overload. The need to assess everyone overloaded the system's capacity to deliver assessments. To quote, this inevitably diverts scarce resources away from carrying out assessments for individuals who clearly are subject to measures which amount to a deprivation of liberty and who need to have their cases dealt with promptly. Paragraph 103. But it also impacted all the other people before the Court of Protection for all the other things who desperately need prompt assessments for all those other issues not related to Article 5. The court noted it also represented a wholesale intrusion into people's lives. Paragraph 102, the assessments required of an individual for the purposes of the dole scheme, which often have to be repeated periodically, can be both intrusive and distressing for them and their families. These assessments will not generally have any therapeutic or other intrinsic benefit for the person. They may well require disclosure of sensitive personal data. Moving on to the law, Cheshire West was also counter to the Strasbourg jurisprudence that we seek to uphold. Paragraph 183. The Strasbourg jurisprudence to which we have referred confirms that the European Court has continued to apply the multifactorial test in determining when an individual is deprived of liberty. It has never adopted an acid test. At paragraph 193, the court noted, the European Court has emphasised that Article 5 is concerned with the physical liberty of the person. The court also noted that a blanket test makes no allowance or consideration of an individual's unique circumstances. To quote the ruling, the acid test in Cheshire West takes no account of the innate limitations to which an individual may be subject by reason of their own physical or mental condition. Paragraph 195. Now here the court gave its full weight, its full backing to Mrs. Justice Leven, whose approach has been heavily commented on by the COP commentariat. SM was wholly incapable of leaving, both because of physical inability and because she was unable to form any intention or desire to leave. In our view, the judge was right to conclude that this situation did not involve a deprivation of liberty within the meaning of Article 5. The court also considered cases of advanced dementia, where someone, to quote, may be so cognitively impaired as to be unable to form the idea of swallowing, let alone moving about. In this situation, no one is interfering with, limiting or controlling their liberty to do anything they can do. In this context, the court quoted and approved Professor Eldergill, who demonstrates that legal writing can be poetic as well as insightful. Wishing or deciding to leave fall into the category of things which the person is now incapable of doing, and one cannot properly speak of being prevented by others from doing something which one is incapable of doing. Nor can anyone possibly restrain a person from doing something which they do not have the ability to do at present. Mere inability is not lack of freedom. Paragraph 197. It was interesting to note that the common law is not engaged with in the judgment, but perhaps a system of nuance and interpretation is well suited to a common law jurisdiction, as well as being consistent with Strasbourg's approach. As well as being practically unworkable, the Cheshire West's approach, and this is now my opinion, has morphed away from Article 5 into care oversight. The court has been complicit in this. On the basis the courts let it happen. They don't say, hang on, this is supposed to be about Article 5, stick to Article 5. It might be that greater oversight of care is needed, but it should not be dressed up, not smuggled in as something else. If greater oversight of care is needed, it should be introduced by legislation or case law, not sneaked in under another cover. Will this ruling make a system that is better or worse? I have no idea, but I do know that a system that is unworkable, but which has lofty principles, is much worse than one which may be less philosophically pure, but actually functions to protect those it seeks to serve.